where our customer had curious questions about different terms that appear on the contracts on your side, on our side, and the vendor side that we're not an expert in. And then sometimes we get stuck with some of those languages that we signed up for, and then we end up paying consequences when something does go wrong, right? So we figured there might be a good idea to get people in a group and have a little conversation about what kind of challenges do we face, and have somebody like Pam on the roster to guide us through to see what does that mean. What does indemnity mean? You know, how does it affect me? What if I sign up for liquidated damages? What am I signing up for, right? Or what if somebody sneaks in some kind of a wording that I'm not familiar with? What are my options? You know, curious questions like that came up a lot. So we figured we would all benefit from a group session like this. So that's why we invited you guys to join. With that said, I want to just go through some of the basic housekeeping rules and hand that over to Pam. We have gift cards for you for a brave individuals who wants to raise their hand and ask an interesting question. So we can send you a Starbucks gift card in the mail to you. So I would encourage you to just stop Pam in the middle of presentation and say, hey, I got a question. I don't understand what you're saying. That at its own face value, it'll be at least worth the Starbucks gift card, right? So don't be shy to raise your hand and ask the questions. There will be a half-an-hour break between this and the lean seminar, so we can go back to checking our emails and do whatever we need to do. As they call it in today's technology world, the bio break. The last thing I want to mention is that we're going to try to keep everybody mute so we don't get background noise, but you are encouraged, and I hope that you would have questions as she's explaining something, to just raise your hand on Team. I hope everybody knows how to do that, right? Everybody's used Teams, that should know that there's an icon on top with a hand, and then you can just click on it. And that way we will identify you that you have a question, and then we can stop and have that answered by Pam, right? Does everybody? Tony, you got your hand up, so that's good. Just like you did that, that's the way to do it, right? Okay, good. You're testing it. So I'm done with my piece of the speech, and then I'm going to turn it over to Pam, and she can give us a little bit of a background of why she is qualified to talk about this thing than any one of us is, right? So thank you very much, Pam. Here you go.
Thank you, Perry. My name is Pam Schofield, and my current occupation is a construction law attorney. Prior to that, I started my career with General Electric as a engineer in their power distribution division. And at one point in time during that career, I got transferred to San Diego and became area manager for the electrical distribution and control division, where I met One Source Distributors. This was many, 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 many years ago. They actually had a different name at the time. So I actually worked for One Source Distributors as an outside sales engineer after I quit General Electric on my 10th anniversary. So while I was in law school, that's who I worked for, was One Source. And so I know this industry for my whole adult life. I've bid projects. When I worked for GE, we used to have these types of lunch and learn seminars, but we were generally going over takeoffs. How do you do a takeoff? What control products do you apply? How do you, I never really did lighting. It was mostly switchgear, controls, that type of thing. And so when I became an attorney, I naturally stuck to this industry. And then my client base started being distributors and contractors and OEMs and people who are in the construction industry. And then I started doing more and more, helping them get through contracts, as well as handling disputes, whether they're payment disputes, change orders, delays, indemnity, liquidated damages, and what all those things mean. I've litigated all that stuff, as well as help clients walk through their contract terms. And so today's presentation, I picked about 10 contract terms that cause the most grief to anybody who's trying to do work or sell products or, service a customer. And some of them tend to be a little bit more confusing than others. There are a lot more terms. If all of you have probably experienced a contract that has like 20 pages, 40 pages, and you're like, why do I need this? Who wrote this darn thing? It was probably an attorney. But anyway, it's there's so many terms, and the words that you're going to see today aren't always the actual words you see on your contract, but the concepts are there. And so again, I picked about the 10 most concerning types of terms that we all run into in this industry. So I'm going to go ahead and share my screen now. And I will emphasize what Perry said. These are more interesting live at times because people can ask questions on the fly. You can still ask questions. It makes more of a good conversation, and it helps me keep focus perhaps on things that are important to this particular audience. So I'm going to share my screen. Let's see. And this is the handout. So can you all see that, and is it big enough? Anybody? Because I can't see you so much when I'm sharing my screen. Let me pull you guys over to the side.
We can see you.
Okay, good.
We can see the presentation.
Okay, great. Can you still see it? So
yep.
This is the
hand raised too. Just
oh, okay.
Yeah.
Somebody raised a hand.
Tony's hand is still up because he hasn't taken it off yet.
Ah, okay.
Okay, cool. So one of the other things I learned when I was actually trying to sell switchgear to end users or sell our designs to engineers or whatever, I always was searching for another way to get in front of the customer. And one of the ways you can get in front of the customer is to tackle the terms and conditions or the contract as soon as you can. And believe it or not, in my experience and in the experience of other clients, you can actually establish a really good relationship early on if you go ahead and start talking to them about any concerns you may have with the contract terms. Say you want to make sure you understand what they need. You want them to understand that you're all on the same page. So people underestimate the ability to negotiate as actually a really good sales tool to get in front of the customer and establish a good relationship early on. The other thing that people don't realize is like, this is a $5,000 order. So what? How much trouble can I get into? It does not matter what size the order is. If you signed up for indemnity and whatever you installed or wired or sold them causes a fire, you're going to have millions of dollars of liability. Same with liquidated damages. Let's say you order, just a motor control center and the truck hits an overpass on the way to the job site. Yes, I've had that happen. And you promise that, regardless of the reason, I'm going to pay you liquidated damages if I don't deliver on time or I don't install on time. And so even the smallest of orders can cause you the biggest monetary headaches. So again, I call these the big 10 contract terms you need to understand. So there's also a difference between trying to negotiate. A lot of people maybe don't feel comfortable negotiating terms, and if you feel that you can't negotiate it, you got to accept it. In my mind, 99% of the time you should be able to negotiate. Some of the terms would be better for you, but maybe you can't, maybe you don't want to, maybe who knows what the reason. Then you really need to understand those terms so that you can make sure that you manage your project, manage your order or whatever it is appropriately to keep away from getting yourself into trouble. It does you zero good to not read your contract or the terms and conditions on a purchase order. Even if that order, a lot of the big customers now say, hey, here's the order. Our terms and conditions are online. You better go online and grab those. Otherwise, you're not going to know. And again, this is not a time to put your head in the sand. Is it hard to understand? Absolutely. Don't try to read it all in one sitting. You got to digest it. And so that's what I do. I mean, I still, after 20 years, sometimes I get this a contract that's just horrendous. It's got, it duplicates all the same provisions all over the place. And, you can't do it all in one sitting sometime. You just have to digest what you can, make notes, and then move on. But, so we're going to talk a little bit about what the terms mean. I've left you spaces on your worksheet to jot some notes or remind yourself to ask a question, however you want to use it. The whole purpose, everybody's in business, unless you're independently wealthy or have won the lottery and you just love to come to the office or stay at home and work all day, is to get paid. And one of the hardest things for a contractor or a distributor or an OEM or anybody who sells any services or product is the pay if paid, pay when paid. And that is a term in your contract that says until your customer gets payment from their customer, they're not going to pay you. And I'm hearing a little bit of background noise there. Am I the only one who hears that? Sorry. Thank you. Anyway, so if you sign up to that, your customer is going to think, well, I don't have to pay you until I get paid. And in California, and again, that's another ground rule I forgot to tell you. I'm talking about California law right now and in our lien seminar, because every state has different laws. So if I tell you that something is illegal here, it doesn't mean it's illegal in Nevada or Arizona or some other state. Every state has slightly different contract rules and what you can and cannot contract for. But pay if paid and pay when paid the pay if paid is not legal. You cannot, as a contractor, if you're selling to a project, your customer cannot say, hey, I'm not paying you unless the owner's paying me. It'll be in your contract. And the reason it's good to address it is because their accounts payable person will not understand that it's not legal, and you don't want to have that argument. So what I suggest, if you have any of the language or any wording that says, we don't have to pay you until we get paid from our customer or we get paid from the owner or whatever it says, you change it up a little bit and try to put a maximum time. Say, okay, well, you have to pay me within 7 days of you getting paid, but no later than 45 days from the time I turn in my pay app or my invoice, something like that. You try to cap that time. And that's been the most effective way. And then if you get more complicated, it'll get into issues of, well, what happens if you cause the owner not to pay? Well, that's another whole issue. So you can start getting more complicated language, but the most important thing is to have a deadline of when your customer has to pay you, regardless of whether or not they get paid by the owner or by their customer. Retention is another thing. Mostly, again, if you're a direct sell OEM or to a project, and it's mostly project based, retention is the amount that they're going to hold back from each one of your invoices until sometime in the future. Your customers want it to be once they get their retention, and you want to fight back a little bit saying, well, hold on, once I'm done with my services, my work, my scope of supply, you need to pay me back the retention that you held from me. The purpose of retention is so that you'll come back and handle, warranty issues for a short period of time, or what they call punch lists, or maybe you had some missing components or parts, or maybe you owe them as-built or something at the end of the project. So that's the purpose of retention, is to hold back some money to kind of give you an incentive to make sure that you finish up what you promised you'd finish up. But it doesn't make sense in all situations. So what I try to do with my clients there is to negotiate a date certain that your retention will be given to you. This is very, very, very hard to do for a contractor or a subcontractor, because your customer, your general contractor, is likely not going to get your retention back until the whole project is done. So the best you can do there, in my opinion, is to make sure that your general contractor is not holding back 10% of payments from you, when in fact the owner is only holding perhaps 5% retention. So you want to make sure the amounts of retention match. Public projects in California, again, not federal, but public projects in California now limit a public entity's retention rate to 5%. So if you're doing any work on a school, Caltrans, a city building or whatever, and it's a public project, you need to make sure that your customer, whether it be a higher tier sub or a general contractor, is only holding 5% back from you because that's all they're being held. So that's how retention works. The next thing is this thing that legally it's called an integration clause. That's kind of just a legal name for what this type of provision does. And it basically says that it basically is the concept that once you sign a purchase order or a subcontract or whatever it is with your customer, that's it. There are no other documents, no other emails, nothing is part of your contract. And the reason this is very important to you is because if you've bid something, whether it just be, again, a scope of supply or work or services or something, and maybe in your quotation, you clarified things. You're like, okay, well, I can provide you this, but I can't provide you that. Or if you're an electrical subcontractor, you're excluding temporary power. You need to make sure that those exclusions and those clarifications are actually written into whatever it is you've signed with your customer. They've got to be in the contract. You cannot go back later and say, oh, well, my quotation excluded this little part of work, or I said I'm not going to give you the fuses for the safety switches, or whatever it is. And too bad. Once you sign that contract, that purchase or whatever, that's it. That's the contract that's between you going forward. Stuff in the past doesn't matter. Sometimes you get excited because a contract might refer to your proposal, but usually it has somewhere in its own terms that it's only doing it to clarify the scope. Another issue that comes up with this, what's included in the contract, is sometimes it also basically will give you a list of drawings or spec sections that are inclusive. And if you're trying to be very careful that a certain spec section is not your work, you need to have that written as an exclusion in your contract. And then this leads me to incorporation of the prime contract. I gave you a very, very typical wording. Basically, most every subcontract that a subcontractor will see, as well as a distributor, as well as an OEM, anybody who's providing anything to a project, you're going to get language in your order or subcontract that basically states that you're agreeing to all the terms that your customer has agreed to. If you don't have your customer's contract, you can't possibly know what those terms are. And this is important because even though your order terms or your subcontract doesn't mention it, you might have terms in there in the prime contract or the general contractor's contract that say things like, if you don't put a claim in within 2 days, you've waived your rights to the claim, or they might have limitations on your profit and overhead that you put on a change. It might have things that you can't add to a change order. So there's a lot of things in the prime contract. It might have liquidated damages, which is not mentioned anywhere in your order. However, there's, you'll still owe the liquidated damages even if your subcontractor order doesn't mention it, if you've agreed to all the terms of your customer's contract. Does that make sense? And this one's actually really bad because this term says that you're also bound by all the decisions, rulings, and interpretations of the owner. And that runs into problems when you have a change order pending with your customer that's due to an owner change. And so what this means is that if your customer, usually the general contractor, negotiates your change order with the owner and they come back with a decision, you're stuck with it. And you don't want that to happen. You want to be involved with any time you're negotiating your own changes. So you have to be very careful on some of this language that just looks like, that's routine. It's not going to affect me much, because it really can affect you.
Pam,
Wine
can we
black.
take a break for any questions that anyone might have?
Sure.
Does anybody have anything on those first 4 bullet points that we touch base that you guys would like to discuss or ask any questions on?
I know this is going to go fast if I get no questions. Are you all shy?
Hey, Pam, it's Mike in Hawaii.
Hi.
So you kind of touched on it briefly, but what happens when, they do send you the PO and it is different than their contract? You just reply back saying, per contract? Because, you get in the battle of the forms. And that was always the thing when I worked at my last distributor was we always were like, well, our PO was the last of the battle of the forms. And you get going back and forth. When you work out a contract up front, and then they send a purchase over with their standard terms and conditions, how do you want the team to handle that? Do we not take the PO unless they include a copy of the new contract, or do we have them make a comment? So I ran a lot going on here. Sorry, if you already answered, I apologize. You're getting
No, I haven't answered that. That's a good question. That brings up 2 issues. The first is when you say you've already agreed to a contract, I'm assuming you have some master agreement somewhere with this.
Well, let's say you're doing a project with like WASA and, there's liquidated damages or you work it out. But then the purchase order comes across with their standard terms and conditions, not referencing the contract that we've written. At that point.
So you literally have to, what I would do on the face of the purchase order or a second page before you get the terms and conditions is clarify those. And then you have to use language like, these are clarifications that will override the standard terms and conditions. Or if you actually have a pre-negotiated contract with your customer, then you would say that this purchase order is based on those terms and not the buyer's standard terms and conditions. So you definitely have to, and it is a good question, because if you agree to the prime contract, but it has actually different terms than your subcontract or your purchase order terms, usually those terms on your purchase order or the subcontract will say what has priority. And unfortunately, it usually says that if there is a conflict between the prime contract and this subcontract, or the prime contract in this purchase order, then the term that provides the most stringent against seller prevails. And
let me ask you this. So if we do a job folder, because what'll happen is like their PO on the large stuff, gear and large bulk purchase, that'll come over with the contract we wrote for the project. But then the change orders come over on the normal POs. We'll put them on the project account. Do we need to? So that's when you get that fine.
I would address it on the change order. Say, hey, we can't sign this, or kick it back to them. Say, this change orders per the terms of the original.
Even though it's on a project, and even though everything else has been on those terms, they could come back to us and say, oh, but this one's different.
Yes, unless you have an actual contract for that project that you both signed that said that these terms prevail over any other form or document that gets exchanged between the parties. So you basically say that in that contract that you signed for the project, you would say that these terms apply to any purchase orders, any quotes, anything that later gets exchanged between the parties. And so you would add language like that into the first contract that you sign. And if you don't have that in the first contract, then you have to get it on the purchase order that's really a change order to the same project. Right?
Okay.
So yeah, it gets a little, you just have to
note, like, can we just ask them to put a note on the PO that says agreed upon terms and conditions for project apply or something like that?
Yeah, for sure. And
so we can just call back and request that they've got to put that terminology so that we know we're covered.
Yes. Okay. And me being an attorney, I would put whatever the date was that you signed that first agreement.
I just want something easy for the employees, because it does happen where the change orders is the ones that don't get referenced on the PO.
Oh,
it just comes across and they don't reference the original contract. So just want to make sure that we can just make that quick statement or ask them to make that statement.
Oh yeah, for sure. And that would be absolutely normal and standard and everything else, to be very clear on those later POs that are for the same project, that the same terms apply.
Well, Pam, you know I'm normal and standard.
Yeah. I know. Nothing's normal in this industry, actually. But if they push back, just say, hey, this is pretty standard stuff, you know? Okay, thanks for the
Thank you.
question.
Sure, thanks.
So for termination, there's two ways that a contract normally talks about termination. One is for convenience and one is for cause or for breach or for whatever you want to call it, meaning you did something bad, so they're kicking you off the job or terminating your contract. For convenience, that means the customer can cancel or terminate the contract at any time. And a lot of times it states that your customer is only responsible to pay you for the work completed prior to termination. And it leaves it at that. And so what that means, if you're an OEM providing equipment or a distributor, it means that if you got, or even a subcontractor, if you've got stuff shipped or about to ship, or you've released for manufacturing and all this stuff is on its way or about to be on its way, you're going to eat that. You're going to try to return it and you're going to eat that cost. It's a huge, huge cost. So out of all the terms we talk about today, this ability for your customer to cancel it's huge, because you really have to know, especially as a contractor, what you've signed on with your distributor or your vendor or your supplier. And so for convenience, if they're just, trying to cancel your order or your contract, I usually also add in they're responsible for work performed. I like to use the word performed here, because you may have started something but not complete it. Oh, it's pink. That's nice. Performed. And then I also add stuff. I also add like, if they say that they have no liability or cancellation charges, I strike that. And then I'll say perform prior to termination. Then I'll do something like plus cancellation charges imposed by manufacturers and vendors. And sometimes you have demob costs, things like that. So you need to really think about, okay, if my contract gets canceled when I'm halfway through it, what costs am I going to incur in trying to, wrap that up? And then you have to list them. And that's very, very important. Otherwise, you're kind of SOL. You're going to be having either a lot of equipment you can't use somewhere else, or you're going to be paying a lot of cancellation charges out of your own pocket. So you really got to think about it.
Perry has a question real quick as well.
Sure.
Go ahead, Perry.
Yeah, I mean, I'm sure eventually you're going to talk about it, so I just wanted to put that out there. When customers or any other party to the contract refers to not a written contract, but just refers to a website, and the consequences of us accepting that with one line being saying, if this contract is subject to all the terms and conditions that we have on the website. Yes,
that is. You need to download those and read those, because that is part of the contract, period. And so if you download them and read them, then you can either mark them up, or you can add another page to your purchase order that's titled, clarifications to standard terms and conditions. Then you say section 3, let's say 5, section 5, termination. In addition to being paid for work completed, we also get paid for work performed, plus cancellation charges, blah, blah, blah. So I'm glad you asked that, because one, you got to download those terms and conditions, because that's part of your contract, so you can read them and understand them. And two, there's two ways that I found are most effective to negotiate a PO or terms and conditions. One way is actually literally going there and do what I did, which is, I'm assuming you guys can see my markups there, right?
Yeah.
Okay. You can either type it in, or if it's a Word document, try to track changes, or do something we call an addendum or an exhibit of clarifications, where you just write down what you guys have agreed to in addition to what the standard terms are. And usually you'll reference what section it is, like section 6 warranty. You know, we're basically clarifying this, that subcontractor only has to do this, this, and this. So there's two ways. And unfortunately, there's no standard way. Your customer may prefer you to list down all the changes on a separate sheet of paper, or your customer may prefer you to literally redline it like I'm doing now. I mean, draw lines and write different wording and things like that. So the earlier you get the contract in your possession, the better. And that being said, if you know your price is good, the moment you think you're going to get an order or be awarded that scope of work, you need to ask your customer, what will the terms be? Because if it's a general contractor you're dealing with, they have to let 20 to 60 subcontracts, and they're going to put you at the end if your work is later. You need to ask them for their standard contract terms, because a lot of times, again, they're 20 to 40 pages, and you want time to read them, understand them, and try to change them. If you wait till they're asking you for submittals, hey, I need your submittals next week. Here's your purchase order, or here's your subcontract. Read it and get it, sign it and get it over to me. And they give you 4 days. You're already starting out in a very, very bad position to try to negotiate. And you're going to irritate the crap out of your customer, because you can't get through all those terms in that amount of time. So as soon as you know you're in the running and you have a good feeling, say, hey, look, how do you guys order? Do you use your terms? Do you sign my proposal? How does that work? And engage in the conversation. Get in front of them. It'll show that you really do care, because you want to make sure you're doing a good job for them. You understand their needs. So
I would like to find out from the group if anybody has experienced those kind of languages where they were redirected back to a website for reference to a contract. If anybody in the group has experienced that, have you guys come across? Anybody?
Not yet. And so it would depend on what you do. If you're doing work directly for an large industrial customer, we see that quite often. We see them tending towards referencing some sort of standard terms on their websites. If you're doing a traditional construction project, I haven't seen that quite so much yet, except when a subcontractor is ordering perhaps equipment, they may try to have some standard terms and conditions on as a contractor on their website. But I think it's going to, the other thing that you'll see is sometimes when you bid a job, they make you go online to pull down all the bid documents, and there's a sample contract there. And a lot of times their bid documents will say that just by submitting a bid, you're agreeing to their standard terms and conditions. That's a red flag. You need to look at it, and then you need to understand it, because that puts you in a very precarious position. Do you call attention to some stuff you don't like ahead of time, or do you make sure you understand it and you price it accordingly to your risk? So we're going to be seeing that a lot more, where these contractors and owners are going to try to force you to accept their terms when you're bidding their work. And so every situation is different, and you just need to decide.
Hey, Pam.
Yep.
So it's Mike again. So in Hawaii, we do a lot of government contracts and city and state stuff. And those contracts, they're just not negotiable. And they're not necessarily written in our favor, but there's nothing you can do. So you either take it or leave it. So
right, and that's exactly,
especially with Rockwell, with city and county, like you just have to do it. And so what are your thoughts on that stuff?
Well, that's why you need to know what those terms and conditions are at the beginning, as soon as you can. And you're right. Very rarely would I see a public or federal entity allow you to, in your proposal, try to say, hey, I don't like this term. So you're right. Most of the time you are stuck with it. The only thing you could do at that point is when you're trying to get proposals from your vendors or your manufacturers, you tell them, look, I need to know whether or not you guys can deal with this or not. The biggest issue is usually warranty, where the state or federal contract has a longer warranty, or they require that you provide the cost for pulling it out and reinstalling it, which most manufacturers won't cover in their warranty. So the only thing you can really do, Mike, is go to your main vendors or manufacturers and say, hey, are you guys okay with this? And then if they're not okay with it, somehow, if you really want the work or the project or the order, you're going to have to put a price to it and say, okay, well, you know, if I was aligned with the manufacturer here, you know, I could be really competitive, but it looks like I'm going to have 18 months of exposure where I'm going to have to pay Rockwell or whoever to come service it because I signed up for a 3-year warranty and they're only warranting it for 18 months. So you're going to have to figure out what terms and what you can pass through to whoever you're buying from. Unfortunately, that's the only thing you can do. But the federal stuff's not as bad sometimes as the municipal and state stuff because they're regulated by the FARs and stuff like that. They're not as bad as some of these municipalities and school districts and all these other people who write their own terms. So.
Yeah, the only other crazy terms I've seen is when the rail project was going on and Shimmick Granite and Trailer came out, which was like a conglomerate. Those are some nasty terms. But I was at Westford then, so I don't know what you guys did with it. But those are the worst terms I'd ever seen.
Yeah, and so in that case, you had a joint venture doing a very large project for a government entity. And the problem there is, and we'll get to it in a second, liquidated damages. So remind me to talk about that for LDs. Because, you know, I'm going to talk about LDs and the size of the contract. I'm making a note there, and I'll get there when I talk about it, liquidated damages, because that is a big risk. And like I was just saying, warranty is usually what the contract documents require. And the term contract documents usually means the prime contract and all the specs. And the problem there is that you might finish your work, or you might finish delivering everything, and the project goes on for another year. And so the contract documents are going to say that the warranty period starts at substantial completion or final completion of the entire project. And so, but your manufacturers are only usually warranting equipment, especially electrical stuff, anywhere like from 1 year shipment or 18 months from startup. And so the important thing here is to try to close that gap of what your customer is asking you. You need to ask, well, what's the estimated completion date? You need to find out if the manufacturer offers an extended warranty. And so it's usually at a cost. Well, will they warranty their stuff from 5 years after shipment? All right, well, that's an extra cost. But I know it's really, really, really hard to do this, but you need to figure this out of what the project warranty requirements are before you give your proposal. You must do that. And go look at the prime contract documents. If it's a public project, they're published. And that's where you usually get some of these longer warranties. That way, when you give your customer a proposal, you can say, hey, manufacturer's warranty, they'll do 5 years from shipment at X amount. Now you at least have a leg to stand on when it comes to negotiating to say, hey, I told you guys, here's standard, and you got to buy 5 years extra to cover. We've also had success negotiating a date certain where we ask the customer, all right, when will your project be done? They say, okay, it's probably going to be done on X date. And we'll say, okay, we'll warranty it from that date on. But if the project gets delayed, if it's no fault of ours, that's when our warranty is going to kick in, period. And then you can manage at least the time. The other thing that is problematic, mostly if you're an OEM or distributor or somehow a supplier and not doing the physical work or the install work on the job site itself, is the in and out costs. And that's the cost of removing the defective product and reinstalling it. And if you're doing fixtures or anything else, that gets very, very expensive, and the manufacturers generally will not cover that. So you just have to be very careful on what that scope of the warranty is, what's expected, what do you got to do, as well as the warranty time frame. And again, that's where, remember, that's where if you incorporate the prime contract, that contract document, even if you negotiate a term with your customer saying, hey, it's 12 months after 12 or 18 months after shipment, 12 months after startup. If you've agreed that the contract documents also apply, then you could be stuck with a longer warranty than you realized. Indemnity. When I was in law school, I honestly never knew what that word meant. I hated it. We didn't dwell on it in law school, and I really did not understand what it meant until I started working with a lot of clients with a lot of contracts. And it just simply means indemnifying somebody means you're paying the damages that are assessed against them. And it usually comes up where a third party gets injured or makes a claim against your customer. And if you cause that issue, or at least were partly at fault for that issue, you're going to end up hiring the attorneys to defend that claim as well as paying out the resulting claim. So that's what indemnity means. In California, if you agree to indemnify somebody, you've also agreed to handle their defense. Again, most of the time, it's going to be property damage or personal injury, and usually you'll have insurance that'll kick in that'll handle that. But these indemnity provisions aren't just limited to property damage and personal injury and things like that. And so a lot of times there's a ways you can handle that. First, make sure it's tied to your own negligence or your own fault. If you're an OEM and you make equipment or you put stuff together, make sure it has to do with product defect or something that you have caused. And then the other thing is to try to put a cap on it. If you have a $50,000 contract or order and you have unlimited liability, you don't want, for example, let's say you are working with, I don't know, a power plant or a wastewater treatment plant, and you don't really focus on what damages you could cause. You could end up having a faulty piece of equipment that ends up polluting an ocean or something. I mean, it could be huge. And so I always try to get a cap on that. Say, look, if it's a contract breach that I'm indemnifying you for those damages, then 10%, 20% of the contract value, or the value of the item that caused the damage. And then I'll go on to say, but if it's personal injury or property damage, then I'm capped at what my insurance will cover. And that way, you're giving your customer a good compromise that if you really cause some major damage or whatever you sold them catches on fire or blows up and hurts people and property, at least you're saying, look, I'll indemnify you to the extent I've got coverage for that and to whatever my levels are. So that's how I try to work it out. People are very touchy about indemnity. If you mess with the indemnity clause in a contract or in the terms and conditions, your customer is the project manager or whoever you're dealing with is going to go, or the purchasing agent, they're going to go, oh no, I can't change that. It's got to go to legal. And then you just calmly say, okay, well, who do I talk to in legal? Let's see if we can put a cap on that. And that brings me to liquidated damages. Sometimes, so all liquidated damages are, the term liquidated legally means determined, the value of the damages. So that's exactly what liquidated damages are. It's a predetermined amount that you're going to pay if you delay the project. And it's supposed to be used when you can't easily calculate that in advance. And sometimes when you get something like a state project that uses old standards, they'll say, oh, it's $500 to $1,000 per day if you delay the project. That may seem significant, but maybe it's not. If you don't have liquidated damages, then you're obligated for actual damages, and who knows what that would be. So let me go back to that question Mike had said about a rail system, a train rail system. Those types of contracts usually have liquidated damages from $10,000 to $50,000 a day. And that is why you absolutely must know what the prime contract terms are, because you do not want to get yourself into that trouble. And the reason that these large national contractors, They do joint ventures with other large contractors, and then they work the project together, and they're okay with 50 grand a day because their contract's probably 200 million. And because they have control over the whole project, they have a way to recoup those delays that they're causing early on. They can work people faster, whatever. The smaller your contract, or if you're only providing materials or equipment as an OEM or a supplier, you have very little chance to recover a delay caused by a late shipment. How are you going to recover that? Dedicated truck for a few grand, or probably more than that now, given fuel, fly it. I mean, you literally, and so those are the conversations you have with your customer saying, look, I'm willing to pay something if I delay delivery, and usually say, but my delay in delivery has to actually delay your work. You can't just dock me for 10 days late when it doesn't really cause you a delay in installation. Maybe you're not even ready for it. I don't know. And so the more you can think about and understand terms, the better you'll be at explaining what your concerns are to your customer. So is it fair to sell even $1 million worth of equipment, or do $1 million worth of your subcontract and face 50 grand a day for each day you're late with your work? No. I mean, that's just not fair. I mean, comparatively, it's not fair at all. So we've been pretty successful in having those conversations and trying to establish a fair daily rate if my client actually causes a delay. And then we add language that, hey, we've got to be actually delaying the progress of the work and things like that. Sometimes you have liquidated damages that the owner imposes, plus liquidated damages that your customer as the contractor is imposing. So liquidated damages gets very, very touchy, and it's important because it's going to eat your profit margin to the negative very, very quickly. So this is probably one of the, this is worse than cancellation charges that you may not be able to recoup. So if you're going to focus on anything, go for the liquidated damages and understand that, and just write words in your agreement with your customer that limits that somehow, some way. Does anybody have any questions on liquidated damages? So again, don't ignore them, tackle them, understand them, put some caps or limits on it for your own good. Notice provisions.
Anybody gonna take advantage of those free gift cards? Come on, ask a silly question. Ask Pam what does she do on vacation? That'd be worth something.
Well, that would take me forever because I literally just had a vacation. First one in a couple of years. We went to Alaska. The pictures are much more interesting than this.
Get people all engaged.
All right, I'm going to move on.
I have something on my side though. How important is it to make sure we get these changes in writing? Because I know a lot of the times these discussions happen over the phone. How important is it to make sure that we do that with these types of things?
Absolutely important. So I totally know what you're saying, Shannon. We've had situations where the customer's like, yeah, that's in our standard terms, but we never do that. And say, okay, I'm good, but let's put that in writing, because the reality is that if it's got to be in the document you sign. You cannot have an email conversation about it and they agree with you to limit you, and then you sign the document or the contract or the PO that doesn't have that language. It does you no good, because earlier in this conversation, that's what the integration clause is. It cuts off everything that you've talked about or written ahead of time, and what you sign. It's called the four corners rule. It's whatever's, and that's the four corners of the sheet of paper. Those are your terms, or the multiple sheets of paper. The courts are very, very, very likely to not look at an email that was done 3 days before you signed it that agreed to limit these damages. I'm sorry, I'm pointing to my handout. Agree to limit these damages, and then it doesn't show up anywhere in the signed document. The court's not going to give you that protection. So that's a very good question. I don't care what you talked about. I don't care what's in an email. Once you sign it, that's it. You got to get it in there.
Looks like Paul has a question. Paul.
Okay.
Yeah, I was just going to ask, I mean, is it best to just go at an actual rate per day, or some, maybe even a percentage? Or, I mean, like, how do you even how is it determined that it is actually you unless it would, because sometimes, we're dealing with submittals that keep going on and on forever. Not our fault when they're making changes on the fly or they're making changes to the design. But in documenting that, then how is it then, like, how is it then determined that it's our fault if we're doing everything right and documenting that it is beyond our control that these delays happen?
Right. And so what I like to do when I talk, there's usually a delay section that talks about what you're responsible for as far as delays happening. And that sometimes they get complicated. They talk about compensable delays and concurrent delays and all this other crap. But what I like to do is add that this is called the notwithstanding. And that's such a bad word, but legally the word notwithstanding means ignore everything else. If this happens, this is how we're going to handle it. So you can handle that in a way anywhere in your contract that says, notwithstanding anything else, you will not be responsible for delays caused by the submittal review process or anything that you didn't cause or was not your fault. And so it's good to recognize these issues that you have during the course of construction so that you can make note, and you should be, every time you do a contract and you like a term or whatever, you should keep kind of a running list of how to handle it the next time. That's one thing. The other thing is I like the fact that I think you said that you're documenting during the course of construction that these submittal delays are not your fault and these changes are not your fault, right? And so that means notice. You've got to give them notice provisions. If they're delaying you, for some reason this is not working. If they're delaying you, you have got to give them notice. Written notice, the way it tells you to do it in your terms and conditions of your contract. You cannot ignore the fact that they're delaying. Let's say, for example, the prime contract says they're going to turn your submittals in 2 weeks and it's taken them 2 months. You've got to put it in writing to your customer. Hey, we haven't gotten our submittals back. You're delaying my work, period. And then you have to go look in their notice and claims provisions to see exactly when you have to tell them and what you have to tell them. So do you have to tell them that I'm being delayed now? The more notice you can give, the better. That's one thing. But it is also important to, in the delays section of your contract, to put in a list of delays that you're not responsible for. You're not responsible if they don't release the stuff for manufacturing by a certain date. And so don't be afraid to add actual dates. Whatever you need to add, plain language that clarifies the contract. If your customer says, well, we don't need to worry about that or whatever, I mean, I always ask, well, what do you have against actually, in a nice way, adding in writing our agreement here? Because, I mean, reality is that person might not be there 3 months from now. And if it's not in your contract, how are you going to prove to the new person literally that you've all agreed to this? So don't be afraid to put dates. If your installation depends on, or a shipment depends on them telling you to go ahead and manufacture or go ahead and ship something a certain date, just stick it in there and just say, these dates take priority over anything else. So, and then the daily rate is tough when you're not the owner, because it's usually the owner that determines that daily rate. And then the general agrees to it. Then the subcontractor agrees to it. And depending on where you are down the line, everybody's agreed to it. And when somebody says it, I usually say, well, you agreed to it and your contract is millions of dollars. Let's bring this back down to something that we can handle based on our scope and our contract. How can we request the prime contract as a subcontractor in a nice way? That's a really good question, Hector, because I've seen people say, oh, we're not going to give it to you. Well, I mean, I try to talk to them logically, say, oh, okay, hold on. You want me to do good work for you. You want me to make sure I follow your prime contract. How am I going to follow it if you don't give it to me? And they really should offer it up with no problem whatsoever. Tell them they can white out or scratch out their pricing. You don't need to know that. You just need to know what the terms are. And if you're dealing with somebody who won't give it to you before you sign your subcontract, I would think twice about dealing with that contractor because there's no reason not to get it. It's a very, and don't let them say, well, nobody ever asked for that. That's BS. Everybody asked for it, or at least they should. And I hear that all the time from my clients. It's like, well, I tried to ask them for that, but they say no other subcontractors are asking for that. Well, I'm telling you they are, because I service a lot of subcontractors, so they are. You know, General may not like that, but they are. So yeah, they do. They definitely will hesitate to show it to you, and you'll just have to. You just say, hey, and then if there's something you're concerned about, say, well, send me the pages that have liquidated damages. Send me the pages that talk about change orders. Send me the pages that talk about whatever it is. You know, and as we're talking about delays, I don't have this in here. Don't ever sign a subcontract that tells you that the project schedule is part of the subcontract if you do not have that project schedule. Just say, well, I'm crossing that out until you give it to me. And yeah, that's, don't, anyway. So, somebody says that you get the line that legal will get back to you. If they have to go to legal to give you their prime contract, that doesn't even make sense. You know, again, just say, well, when will that happen? And I think a lot of generals think that you'll get all wigged out if they say that, oh, legal has to get back to you, but don't. I mean, they're just people too. And it's kind of like, and I don't tell them this, but sometimes a prime contractor or the general contractor's project manager is kind of like an insurance company. You make a claim, they tell you no and hope you go away, but you're not going away. And if you're, yeah, they just make it say, just say, well, no, everybody I talk to says they always get it. You know, it's really hard. If it's a public project, then you should be able to get that information online. That's not private. You know, it's not private at all. And if you're doing a public project, they can't threaten you to take away the project if you don't sign on to their bad terms. There's, you know, it gets somewhat complicated, but anyway. So let me get quickly through the notice provisions. Again, you've got to figure out how long you have to make a claim, how long you have to tell them that you're being delayed, because those are enforced. And you never ever want to do extra work without getting it in writing. You have to look at your contract and see, does a change order or a directive to do extra work have to come from an officer of the company? If it does, make sure it happens. And if they send you an email, hey, can you change out this wire or whatever, just say, yes, please send me a directive from your officer of your company. And they'll say, why do I need that? Say, well, your contract says I have to have it. It's your contract. I'm just trying to follow your rules. And you do it again in a nice way. But in my experience also, subcontractors who stand up for themselves in a professional, reasoned way, you do not get taken advantage of. Because out of the 60 subs out there, if they know that you've read your contract, you're following your contract, and you're going to hold them to their obligations under the contract, you will not get taken. They'll try to take advantage, but as soon as you push back a little bit, they'll respond to you much better because they know that you're not just some subcontract that's going to get a contract and stuff it in the drawer. You understand the importance of a contract, and that's the image you need to give. It's all your image about how professional you are. The other thing is no damage for delay clauses. This says that if the project is delayed by anybody except you can't make a claim for costs or expenses you incur due to the delays. That's a problem because sometimes you'll be facing material escalation charges, or you have time-based equipment on site like rental equipment, toilets, job trailer, whatever. So if the project, so you just need to look at that and look at your scope and see if that affects you. Again, that affects your bottom dollar. If the project's delayed, you got to keep your equipment out there, but you can't charge them for that delay. So anyway, there's not a whole lot we can cover in an hour. Hopefully that was helpful somewhat. Oh, sorry, resolution. Oh, this is a bonus. Note on dispute resolution. Mediation is okay. That's where you try to resolve it. Arbitration can get very, very expensive, especially if you have a small contract. So basically, if you have to go to arbitration instead of court to get a judgment to collect, these arbitrators cost anywhere between $3,000 and $6,000 a day. Now they're up to $10,000 a day. And so you might have a $15,000 claim, and now you're going to suck all that money out just getting it resolved and getting your judgment. So there, you need to really look at your dispute resolution provisions. That's another thing that they usually go to the contract documents on. Again, it gets a little complicated. And then the contract, if the contract doesn't have other language in it, the American rule is that you pay your own attorney fees and costs. If you're the one on the receiving end of getting paid, you usually want to add that the prevailing party gets their fees, because otherwise you're chasing money. You're going to spend, several thousand, if not tens of thousands of dollars on an attorney, and then you're not going to be able to recover that unless your contract says you can recover it. A little bit different on bonds and stuff, on public projects, but private projects and federal projects, it's harsh if you're the one trying to get paid. Venue and choice of law, if you're working for a big company or a big contractor, they may say that you have to litigate in New York or Texas or Georgia or some other place that's not California. So I usually handle that by saying it's the location of the project, and they usually agree to that. So again, I know I went through this fast. I hope you got something out of it, and just, you're a good contractor. You're going to treat your customer right and convey that to them, which is why it's only fair to have equal, not equal, because they're always going to have better terms, unfortunately, but, better, more realistic terms for your scope and the value of your contract. So that's it. So I'm going to click off this little handout. And
Is there any other questions before we take a break and get ready for the next seminar?
Yeah, just real quick, this is Paul. Could we go back to those first two? Because I kind of missed the first two, or the first four actually.
the first four, so let
Yes.
me, and just so, hey, Shannon, as a housekeeping, people have to sign off this to get on the other one, right? It's a different link.
I believe so. Yes.
Okay, so let me bring these back on.
Shelley, is that correct?
Yes, that's correct.
Okay.
And then for the other one, if you have like an attachment or something, could you forward it to those that are as part of the meeting?
The lien law? Or
Yes.
yeah, they can do that. For some reason, I can't. I don't know. Did I just do that wrong? Let me see here. Sorry about that. That didn't take, at least on my thing. All right, let me try to share again. There
I
it
sent
is.
an email this morning with that attachment, so everybody should have it in their email if they read.
Okay. Yeah, the attachment that I had seen last time was basically the flyer again. So maybe I just clicked on the wrong one. Yeah,
I was attached to the calendar invite, but there was a separate email that went out this morning.
Okay.
Has the email, but I can send it again to anybody that needs it.
No problem. I'll check it. Thank you.
So the first four, and everybody, whoever's heard this, you don't have to stick on. It's totally up to you. The first one was pay if paid, pay when paid.
Yeah.
Basically, your customer. And so the way we try to handle that is to put a maximum amount of time. And basically, if you did not cause your customer to not get paid, then the maximum amount of time might be 45 days, 60 days after you submit your pay app or your invoice. You try to put a maximum amount of time, like 7 days after they get paid, but no later than 45 days or 60 days after you get your pay app. Gotcha. So pay if paid is illegal in California, but your accounts payable people you don't want to have to fight about that when you're waiting for money. Retention is the amount they hold back. The important thing is to try to get your retention given back to you soon after your own work is done, or make sure that they're not holding more than is being held from them. And again, if it's public works in California, I think it's 5%, and it would usually be stated in the prime contract. The third thing is the integration clause. The important thing here is that once you sign that document, that's it. Previous emails, previous proposals, nothing else is part of the agreement. And so if you have exclusions and clarifications in your proposal, you need to actually write those in somewhere in the contract, saying these are the clarifications and exclusions. I'm not doing low voltage, or I'm not doing this or that. And then the incorporation of the prime contract, we touched on this all the way throughout, that it basically says that the subcontractor is bound, or the distributor or the seller is bound to whatever your customer's contract with the owner says. And that could affect all sorts of things like liquidated damages and warranty and all sorts of things. So that's why we had those questions where people are saying, what if they won't give it to me? They have to. If they want you to abide by it, how are you going to know how to abide by it if they don't give it to you? And again, offer them to strike out their pricing or anything private. But you really need to know what the rules of the game are if they want you to promise that you'll follow those rules. So, and you know, that's a
Okay. And then if you said like if we, like, how are we bound to that if we don't, if it's not part of our contract but it's part of their contract? That was the only part that I didn't fully understand on that one.
Because usually your contract says that you agree to be bound to their contract.
Gotcha. Okay.
And they usually define contract documents. They'll either say that you're bound to the prime contract or you're bound by the contract documents, and they'll usually define that. And it can just be a one sentence thing. And so shame on you if you sign it and don't ask them for a copy of it. You can't go back later and say, well, they wouldn't give me a copy of it, so I don't think it should apply. It will apply. And so you really need to get that from them.
Okay.
Again, these large projects that have, you know, devastating liquidated damages or very long warranties are very important for a subcontractor to know what they're getting into.
All right.
And the notice provisions. The prime contract might say you have to tell them within 2 days of a delay that you're being delayed. Otherwise, you've waived your claim.
Gotcha.
So it literally takes hours to get through these contracts.
Sam,
So,
Michael
yeah.
Francis had a question in the chat as well. What are our rights for a cardinal change? Can we be forced to do the work?
Yeah, so a cardinal change by definition is a change that wasn't or couldn't have been contemplated by your contract, or is a bunch of little changes that had the effect of being kicked out of the contract terms. But mostly that would be hard to say no to, because most PO terms and conditions and most subcontracts have in there that they can direct you to do any work that's even somehow related to your scope. And if you're doing electrical, that's a lot of stuff that's somewhat related. And they usually say that if there's a dispute, you'll perform the extra work anyway, and then figure it out under this dispute resolution clause. And so that's why it's important to understand what that clause is. I mean, demand mediation if it's a large change that they're not reacting to. But it's depending on the terms, it's really hard to get out of doing that work that they're directing you to do, that they claim perhaps that, hey, this isn't extra work, or it's not going to delay you, you got to do it. And it really makes things upside down. I mean, you could have a $50,000 order and they're demanding that you do $100,000 in extra work, but make darn sure that it's a written directive or whatever it says in the terms that forces you to do it. If it says it's got to be a written directive from an officer of the company, make sure that they give it to you from an officer of the company. I'll otherwise say, no, I'm not doing it, Mr. Project or Ms. Project Manager. I'm not doing it because your contract says that I'm not to do it unless I get it in writing from an officer. So again, the communications and the written notices and things that you do during the course of construction are very important, but it's hard to get out of doing something they direct you to do that's extra. Because usually you sign something promising you would go ahead and do it. Pending resolution is what it usually says. So yeah, that's a hard one. That's why it's important to know what your contract says. So somebody else has something. I just heard something knock. We typically add verbiage saying that we can do a change order because we try to exclude a lot of terms. Meaning that you can do, I don't know what that means. Typically I've heard saying that we can do a change order. So you're agreeing to the change order provision because you try to exclude a lot of other items. Oh, I see. I see. You, on your scope may, your scope may be very specific. So yeah, that's a good point. A very flexible change order clause is very good for you. If you could say, hey, and if anybody tells us to do extra work, it usually has to be in writing, then we have a right to do it. So that's a different spin. That's pretty good. Anything else?
Yeah, can you kind of like reiterate the question? I don't think everybody got
The question, it wasn't a question, it was a statement.
Yeah, so.
It said, we typically add verbiage stating that we can do a change order because we try to exclude a lot of items. So I believe, then she said, yes. Maricela Rodriguez said, yes, that's what she meant. So basically they work, it sounds like her company works very hard to be very specific on the scope. This is our scope, we're doing this, we're excluding this and this. And then they want the terms to have a fairly flexible change order provision so that they can add more extra work to their scope.
Oh,
So
okay.
in that case, you'd want to say, hey, we get paid if we get a directive from the project manager to do this. The issue that I was talking about is when the terms and conditions say that you are not to do extra work unless it's signed off by an officer of the company. That very rarely happens unless all their project managers are called vice presidents or something. And that's very, very cumbersome. And so you really need to look at that wording in your contract to see if it says that. If it says that, you need to address it, say, do you really want me to stop my work and not do extra work unless you get an officer to sign something to tell me to do it? And say, if that's what you want, we will follow that. Because I mean, it's not practical in the heat of the construction in the moment. You know, usually the project manager wants to be able to tell you to, all right, well, we'll figure this out later. Go ahead and do that work. Well, it'll be 10 grand. Go ahead and do it. We'll figure it out later. And if they don't want that flexibility and they need to have an officer sign off on it, then do not do the work. But if you know your contract terms, you can bring it up to them as you're negotiating, saying, is this really how you guys do business? You don't have the authority to ask me to do extra work. And then if they say, well, yeah, I do, say, well, then let's just put it in there. What authority do I need to do extra work? And then you work it out ahead of time.
What are the consequences or legality of a contractor or a general contractor or somebody else telling us or any one of us on this call that you're subject to everything I agreed to upstream on my contract?
If it's written in there, yeah, that was the incorporation number 4 that we went over. If it's written in there, you are subject to those terms, period. And that's why it's very important, as we've discussed, to get a copy of that contract.
So it is legal for them to ask that question, right? Or incorporate.
Pardon me?
It is legal for them to go that route and just say.
Absolutely.
Agree.
You know what? In the United States, you can contract for anything that's not illegal, or I think it's just illegal, or unless there's a law that says you can't. Again, you know, there's certain laws that protect contractors' right to payment, prompt payment statutes and stuff, but that's a whole nother seminar. But you could pretty much contract for anything so long as it's not illegal. Like you can't take out a contract to kill somebody. You can't enforce that contract because those are illegal. But anything else, man, if you're two businesses, the law gives you a lot of leeway to contract for whatever you want. So, and you can't use an excuse, well, I'm a smaller company or I'm a small contractor, so I was forced to sign this. Well, you weren't forced. You could have said no to the project. That's exactly what a judge is going to tell you. If you want the project and you don't like the terms, then you need to negotiate them or manage the terms. You know, manage them if you can't negotiate them. So I would like to grab coffee so that I can be spunky in about 14 minutes.
Great. Thank you very much, Pam.
No problem. So I actually end here, right? And then I log back on at 2:30?
Correct.
Yeah.
All right.
Yeah.
Thanks, everybody who's still there for taking time out of your day to join us.
Yes, thank you, everybody.
Thank you.